Any mention?
Please, Lordship.
Yes.
I'd like to mention item number 17. Lordship, I pray this matter may come up after 2 weeks.
Okay, Mr. Jindal is on bereavement.
Yes.
I will pray, my lord, at end of June, 29th June or so.
That would be too long. Lord, I'm instructed.
I was ready with the matter today. In fact, I can argue today and Mr. Jindal can reply on next date, whatever.
What is to be done?
The issue is
No, that is that arbitration matter, the execution.
arbitration.
Yes. Now the thing is that today cause is genuine, Mr. DC. So you have to.
At least I'm praying for 2 weeks, subject to your Lordship convenience.
No, that is okay. But then if since you are seeking adjournments, we have to take into consideration Mr. Kumar's convenience also.
Yes, Lordship.
I would pray 27th.
27th June. Oh, sorry. Yes. All right, we'll do that then.
Interim order to continue. Interim order is there, my lord. Interim order to continue.
Entry order. Okay. We'll just say on prayer made on behalf of Mr. V.K. Jindal, Learned Senior Counsel, appearing for the respondent, who is stated to be on bereavement, the matter stands adjourned. Stop. Just as prayed for the parties, list on 27th.
Grateful.
Obliged, Lordship.
The interim order, first order, shall continue till the next day. Yes.
May I please, Your Lordship? I'd like to mention item number 13 and 14.
Item
13 and 14. On behalf of the private respondents in both matters.
State.
13 and 14.
Mr. Lordship. Lordship, I pray
Lordship,
that this
I'm
matter.
appearing for the state in item number 13.
Both the matters are connected matters.
Yes, Lordship.
Yes, Lordship.
Yes.
No objection, Your Lordship.
The sound request made on.
Let the matter come out after 3 weeks, Your
What shall you
Lordship.
have?
Let the matter come out after 3 weeks.
3 weeks. Is it okay?
Lordship.
Yes. Just one prayer made by Mr. So-and-so, Learned Counsel, appearing for the respondent number so-and-so. Come on, not objected to by the Learned Counsel, appearing for the petitioner. This is matter after 3 weeks. Yes, both the matters.
Yes, Your Lordship.
Yes, Lordship.
Please, Your Lordship.
Yes.
Lordship, I beg to make a mention by item 6, Your Lordship.
Yes.
Lordship, in this matter, I'm praying for 2 weeks, Your Lordship.
Why?
Lordship, on the last occasion, we have filed a substitution, Your Lordship. There were 3 matters that has been tagged together, Your Lordship. So in one of the application, we have filed a substitution, Your Lordship. But in the order sheet, Your Lordship, in all the matters, the order has been reflected for substitution, Your Lordship. So we have to file a
Then
recall.
You have to file an application for recalling.
Recall, Your Lordship.
So you have not done it.
No, Your Lordship.
So,
Lordship, I'm praying for
and
2
what
weeks.
about the matter where you should take step for substitution? What you have done there?
Lordship, in that order, registry is directed to. Lordship, I have to file an undertaking, Your Lordship, in that matter.
You have not done it. So
No, Your Lordship, we are
how long
out-
it will remain pending?
Lordship,
for
we are
filing of
awaiting
undertaking?
signature, Your Lordship. Lordship, give me 2 weeks, Your Lordship. 2 weeks.
See, this is a 2016 matter, just pending like that.
Lordship, the client reside out of the state, Your Lordship.
Yes. Just on prayer made by a prayer made on behalf of the writ petitioner. So not objected to by the Learned Counsel, appearing for the respondents. This is matter of 2 weeks.
Highly obliged, Your Lordship.
May it please your lordship. Lordship, on joint request with the petitioner, I beg to mention item number 9, my lord.
Yes.
This matter may kindly be taken up after 2 weeks, my lord.
This is what? Nokma matter.
Nokma matter. I'm for the respondents 4 and 5.
And for respondent 1 to 3.
So there is joint request.
Joint request.
Okay. One joint request made with the parties. List after.
After 2 weeks, my lord.
Yes.
Much.
I love Lordship.
Yes.
Supplementary causeless, item number 1,
Yes.
My lord.
They have filed the affidavit.
Filed the affidavit, Lordship.
My lord, I have received the affidavit, my lord.
Give me that file.
My lord, they have said that the investigation is on, my lord, but whatever they've said here, my lord, my humble submission is that this is clear eyewash, my lord. There is no investigation. The investigation is not at all being done.
How do this court determines it?
My lord, I will satisfy. I'll take my lord to the to my petition, my lord, and I will satisfy, my lord, that the police are not.
I have filed the affidavit. I have drawn record the second post-mortem report.
Then we'll have it for hearing.
Yeah, we'll have it for hearing. Today is for order.
Yes. Mr. H. Khanmi, Lord in addition to he submits that an affidavit in opposition on behalf of the respondent number 3 has been filed in this matter. Stop. The parties submit that pleading is complete. Stop. As paid for. List this matter for hearing after
2 weeks.
after 2 weeks. Yes.
Lovely.
Item number 2.
Yes. Please, Lordship.
Your Lordship, I'm for the respondent, Your Lordship. We won't be filing affidavit, Your Lordship. Let the matter be fixed for hearing.
Has been filed. But then
No,
official
we won't be
indicate
filing,
that-
Your Lordship. We won't be filing, Your Lordship.
So you have taken time for that only before.
Let the matter be fixed for hearing, Your Lordship.
You are Mr. Bare.
No, Your Lordship. SCM Majao.
You are an advocate on record.
Yes, Your
Have you
Lordship.
signed? Vakalatnama.
Yes, Your Lordship.
Okay. Just record. Mr. So-and-so. Learned counsel. Appearing for. There is only one respondent in this.
Yes,
matter?
sole respondent.
Appearing for the sole respondent submits that no objection is required to be filed in this matter. Stop. The parties submit that matter is ready for hearing. Accordingly, listed for hearing on when?
2 weeks.
Yes. Yes. After 2 weeks.
Hello, Blight.
Item number 3.
May it please, Lordship. Lordship, at the outset, I apologize. On the last occasion, I inadvertently missed the list. We have filed the service affidavit, indicating, Lordship, that service has been duly effected.
Anyone appearing for us? Number 2.
I don't.
No one. What is this matter about, Mr. Dev?
This is where, Lordship, that pursuant to a car accident, the criminal trial was started, and then in the meantime, final argument, a matter was proceeded for judgment without hearing the accused, Lordship. Ex parte judgment. Lordships have been pleased to stay the proceeding in the order of 26th March.
And who is the private respondent?
Private respondent is the complainant, Lordship.
Mr. Inteb, Lord Counsel, appearing for the petitioner submits that the service affidavit showing the factum of delivery of notice upon the respondent number 2 has been filed, basing on the certificate issued by the postal authority. Step. However, none appears for the said respondent when the matter is called out today. Stop. The message Bhattacharya, Leonard G. is present on behalf of the respondent. When shall we get it? Then it is ready for hearing. You can proceed for hearing.
It may be fixed for hearing in the meantime if they appear, Lordship.
Because it will remain open for the respondent number 2 to come and appear. Okay, as spread for the parties. This is matter for hearing. After?
3 weeks.
The interim order may be extended, Lordship. until
Interim
further
order.
orders.
Passed earlier. Shall continue. till the next date.
Much less.
Much obliged.
Item number 4.
Shall continue, just make it define me something.
Well, I'm seeking 4 weeks time in this this is a quashing petition. I'm
Yes.
seeking 4 weeks time to argue the case, but I need to place few documents on record. So
Yes, Mr. Oh, this is a matter where interim period was rejected.
Yes, madam. Yes, madam.
So you have not challenged that order in further?
my lord, I'm in my lord's hand. At least the final order is passed.
You have no objection to the
I have no objection, my lord.
Yes. You are Mr. Raghuvanshi.
Yes, Abhinav Raghuvanshi.
Yes, Mr. Raghuvanshi, London Council appearing for the petitioner. Praise for adjournment of matter by 4 weeks. Mr. Kumar Lamed, AG, appearing for the respondent has no objection. Prayer allowed, list after 4 weeks. Yes, it will come after 4 weeks.
Item number 5.
Yes.
Today is fixed for interim hearing, Lordship. This is for interim hearing, Lordship.
What is that interim hearing?
To state the proceedings in GR case number 112 of 2019 pending before the Judicial Magistrate First Class at Shillong.
On what ground?
Lordship,
Whether the parties have this thing.
Lordship, I am appealing for the state, Your Lordship, respondent number 1, and number 2 is the CVI, Your Lordship.
So who is representing CVI?
Your Lordship,
The
steps
step
have been
was taken.
taken. Yes, Your Lordship, step has been taken.
Because this is a case investigated by the CBI, the charge sheet also filed by the CBI, Your Lordship.
So
but the
you
state
do not
has
have
no
anything
role.
to say here.
Lordship, the state will have no role, Your Lordship. Everything is done by the CBI, Your Lordship. Item number 5. Come here.
I'll appear for CVI, but I have not received copy. So you ready for the matter?
I'm not receiving copy. If they can supply me copy on next day.
So we'll list it for hearing. We'll find a dispute at final.
Only, Lordship, if Lordship can come to par 18 at page 10. Par 18, page 10, Your Lordship. There is a statement that in 2022, Your Lordship, Government of Meghalaya has withdrawn the consent granted to the CBI, Your Lordship. But there, that document is not available on the file, Your Lordship.
Anyway, we'll see it when
Lord,
it's these things. Yes, Dr. Majika. You appear here as DSGI or?
SDS, yeah.
Yes. Leonard GSGI has entered appearance on behalf of the respondent number 2. And please, for not of some time to go through the matter. Prayer allowed. When shall we list it?
After 3 weeks.
We'll list
Your
it for
Lordship,
hearing
after
directly.
1 week, Your Lordship.
Lordship, yes. Come for hearing, Your Lordship.
1 week.
1 week, Your Lordship.
I have to go through it. I might need some steps. 3 weeks time. When
Oh, 2 weeks.
2 weeks.
2 weeks. Please, just as far as the parties, this is not after 2 weeks for hearing.
For hearing.
Yes.
Oblige, Your Lordship.
Supplementary cause list, hearing, item number 2.
Oh, that is that yesterday's matter. Yes, you have any instruction?
Lordship, my only instruction is that if permissible, then the matter may be reverted back to us for passing a fresh order.
It is, but then until and unless you given assurance to the court that you will withdraw or recall, how can we do it?
Lordship, we have assessed, accepting that 97 to 2001 But Lordship, if the matter is not reverted back to us, we will not be in a position to.
No. What is needed is that you say that you will recall this notice and all, and we will give you liberty to issue fresh notice in respect of the period which is not covered by the earlier judgment of the court.
Lordship. Lordship, I have the limited instruction that if the matter is reverted back to us, we will be.
Reverted back in which way? We'll quash it and then remand it back, which give you liberty. We'll quash the impugned order or notice, whatever is unchallenged, and we'll give you liberty to issue fresh notice with regard to the period which is not covered by the earlier judgment of the High Court.
Lordship, Lordship, okay, Lordship, but we have already assessed, Lordship. I'll give
See,
you.
like then, if you want us to this thing, see, either you cannot go. If you want us to go into the merits of the thing and all, we are ready for that. If you this thing, but then the thing is that the core issue remains is that if certain period was covered by the earlier judgment, there is no way you can reopen that issue.
Lordship, actually, we have not exactly reopened whatever has been covered by the earlier judgment.
Your order says it has been pointed out by Mr. Shen yesterday.
Yes,
That
Lordship.
1997 from 2001.
Lordship, it is, we have not exactly, we have opened the whatever has been covered by earlier judgment, Lordship. Lordship,
You do not understand. You see, like what has been proposed is very fair.
Lordship.
Because admittedly, the period which stands covered by the earlier round of litigation, you cannot go back to those years. So far the other years is concerned, the liberty will remain with you to take action in accordance with law.
Lordship.
So what is, you don't find it fair? Does it seem to be unfair to you?
Lordship.
Which way?
Lordship, the matter may be reverted, Lordship. We have a limited instruction, Lordship.
We'll revert it by quashing the order. Because there cannot be a remand without quashing.
Lordship.
Can there be, you are not properly instructed, it seems, madam.
Lordship,
At least you take into consideration what can be a legal prayer. If you want it to be remanded, then there must be some sort of interference by this court. Then you should be ready for that. If you remand it also, remand would be only for those period which is not covered by the earlier round of order, the earlier round of litigation.
Lordship.
Mr. Shen, let her have proper, it seems she is confused. Let her have proper instruction.
It's quite fair
If
what
you-
your
if you
lordship
can
is saying.
see-
No. What is very fair, my lord. The period covered cannot be sustained. Remaining, my lord, I am not saying I will give a fresh opportunity and
That
decide.
is what you see, that is your,
very simple.
your submission was very fair on the, yesterday, that you said let it remain open for that. You have no problem giving liberty. Of course, you're proposing then, but then it seems like she is very confused. She doesn't know which way to say.
Well,
You make your officers understand and then come back with proper instruction.
Lordship.
We'll have it on Monday.
Lordship.
Okay? Please understand the legal implication also.
Lordship.
You are a lawyer, you should not act mechanically on what your clients say.
Lordship.
So that is what. You make them understand and then say. Just say straightforward by MSP Veterinary Learned Council appearing for the respondents. List this matter. Give Monday. On
this remain, my lord, pardoned.
This will come
Lordship
up
is
before
hard
this
already,
court.
but
We
only
have
that instruction.
Not hard much. It will come up on Monday.
No, only, this is the only issue, nothing else.
If this is the thing, then that is. And, it's not that very complicated thing. Also. It is for you to understand that.
Lordship.
All right.
And if you are not agreeing also, then also you come back, then we will decide on merits. There is no problem.
Lordship.
Daily causes, hearing, item number 7.
Yes. Mr. Hajarika, what is this? King matter?
Yes, yes, my lord.
Yes.
I have given. You not given to us. Behind the common report.
Yes.
May I please, Your Lordship? This is regarding the dispute between the Nokmas.
Just before this thing, just give the outline is that you have come against the order passed by the CEM.
Yes.
You have approached this court against concurrent decision or it's a decision of reversal?
Yes, I am going to that.
No. You have come against the concurrent finding.
Yes, my lord.
Or reversal, like decision of reversal.
No, I'm concurring finding
So
I got.
EC's decision and CEM decisions both are against you. EM and CEM both are against you.
Yes, my lord.
And what is the ground taken here?
Ground taken means because the respondent number 4 here, they are not coming from the Nokma. Their parents are not the Nokma. They are from the outside. They are Mahari, of course.
So that is a factual aspect.
Yes.
Now can this court go into that aspect and decide it?
No. Yes, that is also one of the point, my lord.
See, we are in a writ jurisdiction.
Yes.
Our scope is limited to judicial review.
Yes, my lord.
We cannot exercise jurisdiction like an appellate court.
Yes.
Now here, if your grounds are total factual and dependent on evidence,
No.
then
yes.
which way this court will go into those
Yes.
and give a determination that someone does not belong to some clan and someone belongs?
Here, my lord, my main point is that the respondent number 4 is not from the Nokma family. That is number one.
That is okay.
One reason.
Just a minute.
Then second is that in the impugn order 15/12/16, they have written that the case they have filed by the respondent in the Guwahati High Court, it was disposed by giving a direction. Though it is they are listing so many cases together, but that particular case 936 of 1982 is not disposed, but they are giving the direction of the district council.
So you want to say there was erroneous appreciation of materials on record?
Yes, and they are telling that this Nokma, this respondent number 4 parents is come into as a Nokma on the basis of the manufacturer document, and they have become Nokma on.
How we will decide there?
No.
Just you have right now till now you have raised 3 issues.
Yes.
First one is that the private
It
respondent
is
doesn't belong to
decided by the
particular
district
clan.
council court, my lord.
Probably this court
Yes.
cannot give a finding on that.
I am coming to that point.
Second one is that what you say that there is erroneous appreciation of material record.
Yes.
That definitely
yes.
you can go into.
Which one challenge?
And the third,
On the basis of that document, they have become the Nokma, which has been challenged by one Jongshan Momin and his wife. And later on it was reversed, set aside by the CM. And since 1978, my lord, to 2003, my lord, during that period, my parents, that is Jongshan Momin, was continuously Nokma. After his death in 1991, my lord, then Mahari, this close relative that is called Sra from the maternal side, they have selected Shura Nankra Marak and her husband Shimran Momin. And in 2017 to 2000, my lord, they have, in the case, they have decreed as a Nokma of the Nankra Akhing land, which has been again challenged by the respondent number 4. And the set aside the order of 17 to 2000 by the CM, my lord. Then we have come to the Honorable High Court, my lord. That into 2004. Then in WPC number 247 of 2004, they have decided that set aside this order and remand back. Again, what happened, my lord? That district council passed that they have disposed the case 10/1/2000.
Let us come to the orders which are.
Yes, my lord. That is
First,
the,
you take us to the order,
Now-
order of the EM.
yes. I am coming to that point, my lord. And
What is that point? You take us to the order.
oh yes, my lord.
Let us read it because
yes,
we
my
will
lord.
appreciate probably if facts are recorded.
Yes, my lord. And another regretted, my lord, that in the writ petition we have not been able to enclose all the document. Subsequently, we will file additional affidavit, and by this honorable court order, we have enclosed all the document in the synopsis, my lord.
Okay. We'll go into all those
Yes.
things if required.
Yes, my lord.
If it is required to appreciate your argument.
Judgment and order in type copy, my lord, page number 137.
Of EM.
Yes, my lord. CM. Shall I read out, my lord?
Just a minute. This court is yet to go into all those things. This was heard how many times?
Many times, my lord. Because long pending
Not in
case.
this thing. There are many. It seems right from 2022.
Yes.
This. Conditions of file is terrible. This is the CM. Where is the order of EM?
Yes, I am coming to that, my lord. EM order. EM order at page number 23, my lord. And type copy in page number 5, my lord. Oh, sorry, my lord. Type copy is, where is the page number? Oh, sorry, my lord. Type copy I have given in the additional affidavit, my lord.
It's better. This kind of things you should prepare a paper book. Very difficult. Otherwise. Where is that order in the writ petition? Page?
Page is 22, my lord. Twenty-two, 17, 17, 17. The synopsis. In the synopsis, it is there, my lord. That type copy also is there.
Will it be possible that you refer everything from the synopsis without looking at the petition?
The synopsis.
See, like looking at two things at a time becomes a bit difficult.
Yes, my lord. That is a problem is there. I have given, but later on I have subsequently I have enclosed in the synopsis, my lord.
In synopsis, all the documents are there.
Almost all.
Almost. Do not say almost. It should be all. If it is all.
Yes, that is the whatever the document we have. All the document is enclosed.
What would be easier for us to take? Shall we go by the synopsis or
Yes.
shall we go by the?
In the synopsis, my lord, we have enclosed all the document except the impugned judgment, which is under challenge here.
But then we need the impugned judgments are more important than the other documents here.
Two things, my lord. Two things, if I can just inject, my lord. One is this: since my learned senior has pointed out the factual position that these are the things which has not been considered by the district council. If that is the case, my lord, if he is hinting in the factual position, my lord, then we will be requiring the record, my lord, to be placed before the.
That is okay. That is okay. We'll just see. Let us
Second
just,
thing, my lord. Second thing, I will suggest, my lord, that a paper book, because my lord, this is the bulky file, my lord, and we don't know, my lord, from which page to which to go to which page, and we cannot get the chronological way, my lord.
See, that proposal should have been there from you before.
My lord,
before that synopsis and all these things are submitted.
My lord,
hassle would have been avoided and only paper would book at.
We cannot put what is in our mind with the opposite party, my lord. It is for their benefit, my lord, because they are supposed to place the case, my lord. We
And
find
just let us see. Let us see if there is any difficulty. Then we will fix this order. Yes. Just take us in. Okay. In that, before this EM, who filed the complaint? Who are the petitioners? You are the petitioner.
Yes, ma'am.
What is your name? There are 4 petitioners.
Yes, because my name was Rikmani Marak, my lord, and Bening Momin.
Just a minute. Here, who is the petitioner before this court?
Before was Shora Nankra Marak and her husband, my
Sora
lord.
Marak and Sora Nankra Marak are same person.
No, it is different. He's expired already.
Sora Marak and Sora Nankra Marak are not same person.
No. Shora Nankra is the same title, man. Shora and Marak. That means in short.
Come to this order of the EM.
Yes, my lord.
See, there are 4 parties shown as petitioners.
Yes.
Sora Marak, Simrang Momin, Malikson
that-
Marak, and Spinson and Marak.
Yes, these 2 are the clan people, my lord.
Which 2?
That is Malikson Marak and Spinson and Marak. Both of them died.
Who are the petitioners before this court now?
No, before this court is now this Rikmoni and Marak.
How they are related to these petitioners?
Because they are the close relative and selected by the.
So how, if they are not a party, before the proceedings?
No, it is substitute, my lord, after their death.
So where is that? Where is the substitution? Give us the thing. Give us the details. We have to get the facts first. Otherwise, this court will be confused. Substituted in whose place, by which order, and before which authority?
Order of 2000.
What is the?
It is reflected in the High Court order, my lord.
This substitution is before this court.
Yes, before this court also.
So it means originally this writ petition was filed by the petitioners named, those who are petitioners before the executive member.
Yes.
When the substitution took place here?
But it is reflected in the.
Mr. Day, is it correct that the petition was filed originally by somebody and then therefore substitution?
Yes, my lord. That is why, my lord, what I was suggesting, my lord, that a record will be very much needed, my lord. Because what has happened, that has not been narrated yet.
Who were the original petitioners here?
Here the original petitioner was Shora Nankra Marak.
Shora Nankra Marak was not a party before the executive.
Because after his death, he was substituted by Rikmoni, my lord.
Where?
In 2013.
By which order?
It is reflected in the High Court order, my lord. It is mentioned there only.
Do not know. The substitution is by this court or before other authority?
By this court, my lord. By this honorable.
How come? If Sora Nankra Marak filed this petition as original petitioner, why there should be substitution? Very difficult.
247.
You have enclosed it?
No, it is no separate order. And it has been reflected in the impugned judgment, my lord.
That means the substitution was not before this court, it was before some other authority. Now we ask you one thing, you say something. See, Rickman and Marak and Benning Momin, they are the original petitioners in this petition? Are they, Mr. Day? Please help us.
Yes,
Court
in
is
this,
not getting anything.
No, in this petition, my lord, they are the petitioner, my lord.
Original petitioners.
Yes, my
So
lord.
they still remain.
Yes.
So in so far as the writ petition is concerned, they are not
Yes.
substituted.
No, my lord.
Okay. Now
And this
where
is
the question?
and this is the second round of litigation by Rickmoni, my lord. Second round of litigation.
Okay. But then just we must know how they are connected. See, so far as the order of the EM is concerned, that is dated 7/2020, there are 4 petitions.
Yes, my lord. And the 3 and 4 is already expired, my lord.
3, 4 already gone.
Yes, my lord.
Now you are representing whom? This you have stepped into shoes of whom? Soramarak or Simrang Momin?
Soramarak.
Soramarak was your what?
My aunt. Own auntie.
Whose aunt? Is this Rickmani and Marak? How
Yes.
Rickmani and Marak and Benin Momin related?
No, they are husband and wife.
Okay. They are
Because
husband and
by virtue of husband, they are become Nokma, my lord. So Shura and Rickmani and her husband Benin is in this case, my lord.
So Rickmani represents Soramarak.
Yes.
And who was Simrang Momin?
Simran Momin is the uncle of Rickmani, my lord. They are the previous Nokma of Nankra Kingland.
Whether Simrang Momin is before this court? No.
No, my lord. They have
So
expired.
only this petition is only on behalf of Soramarak, isn't it?
Yes, my lord.
These petitioners here
Yes.
are representative of Soramarak.
Yes, my lord.
So other 3 are not a part of litigation.
Now, party, my lord. Benin Momin is a party here because by virtue of.
No.
Sorry. Oh.
We're talking about the other 3
Shura.
who were
No,
original
no.
petitioners.
Yeah, sorry, my lord. Yes.
So we are not concerned with them.
No.
Okay. Yes, let us see the order.
Keep this. Order 17/2000.
Yes.
May I please, your lordship? This case referred to the appointment of Aking Nokma for Nankra Aking number 5615 for which the petitioner have filed their petition and accordingly cases are registered and given the number shown above. At this state, it is only just that go through the history and fact of the case. Number 1. From the record available, it is found that as far back 1973 to 94, there was an Aking case for the same subject matter. That is the appointment of Nokma for the said Aking, which was registered by number 35 of 1973, 74 should be, contracted by the Sri Jongshan Momin and others, and versus Sri Alipshan Marak and others, the present opposition party member in the court of the Honorable
Alipshan Marak is
Executive.
the present opposite party, okay?
Yes, my lord.
Okay, in the court of the
Honorable Court of Executive Member EM. Executive Member Garo Hill District Council herein after GDC Tura, which was disposed of the case on 23/7/1976, appointing Sri Alipshan Marak and Srimati Mene Marak as Nokma of the Nankra Aking land. With effect from 23rd July 1976 and with a further direction of entering their name in the Nokma register genealogical tree, etc., against which the aggrieved parties.
Mr. Day, you can sit down.
Yes, my lord. I was in
Or you
some
enjoy
press.
being, being a standing counsel?
Who is the aggrieved parties Sungshan Momin and his wife Rane Marak have filed an appeal in the Court of Chief Executive Members ZDC Tura, which was registered as ZDC number 12, Miss Case 1977-78, my lord. That though the Honorable Chief Executive Member herein refer as CM ZDC Tura has issued notice to the parties concerned and followed the due process of law in this regard, could not dispose the case finally, though he wrote the final judgment on 3/3/1978, which could not be delivered. Subsequently, the Honorable High Court in Civil Rule number 400 of 1978 on 18/1/1980 has directed the CM ZDC Tura to dispose of the said appeal in accordance with law. In the meantime, there was some changes of the administration in ZDC Tura and the matter was kept still pending for disposal. Next. Finally, Sri J.P. Wesley, the then administrator ZDC Tura, has disposed of the matter on 25/3/1982. It is a fact that the said administrator has very carefully gone through the entire case record and all other connected material evidence produced by the parties, and he came to the conclusion that the pronouncement of the judgment recorded by the learned CM on 3/3/1978 would fully meet the end of justice, equity, and fair play, and that it is the only manner in which the present appeal can be disposed of. Number 2. There, upon the opposite parties, Sri Alipshan Marak and Srimati Mene Marak, having felt aggrieved by the order of the said administrator.
What happened? That administrator's order upheld the decision of the EM.
Yes.
Nothing has been reflected here. So if you say something, then you should say correctly.
Here, during that time, administrator is there.
Yes.
Because there is no district council, so DC has taken over.
We have got this. The court is asking. Please try to understand the question of the court.
Yes, ma'am.
Now, when this order dated 3/3/78 was pronounced by the administrator, saying that that is the
order prepared by the previous CM, my lord, and administrator.
And he said administrator upheld that.
That upheld.
What he said would fully meet the ends
yes.
of justice, equity and play. So that means administrator has gone by that order of the.
Yes.
Is it not? Is not
Yes,
it?
yes.
Now what is that order? Whether that order upheld the decision of the EM or it has reversed.
It is reversed.
So decision of the EM was reversed. That means the decision.
That is the EM
EM's order dated 23/1976 was overturned.
Yes, ma'am.
And then in by 78 order, who was appointed as Nokma?
That's Junction Moment, my lord. Previous Nokma.
Okay. So that 78 order?
Yes. Junction Moment.
Junction Moment.
Yes, ma'am.
Just a minute.
Number 2, my lord. There upon the opposite part.
Wait.
Yes.
Wait. Let us do it.
Yes.
That is Jongshan Momin.
Yes, Junction.
Yes.
Number 2, my lord.
Yes.
There, upon the opposite parties, Sri Alipshan Marag and Srimati Manem Marag, having failed aggrieved by the order of the said administrator, GDC Tura, dated 25/3/82, has filed an appeal in the Honorable High Court at Guwahati, which was registered as Civil Rule number 936 of 1982. As because the opposite party's appointment as Nokma to Nankra Aking by the CM IC Revenue Tura was reversed by the administrator. Next, my lord. The present petitioners Srimati Shura Marak and others, though not originally the contesting parties at the lower court level, having got an interest on the subject matter by virtue of their appointment. It is important, my lord. Appointment on 14/9/1991 as the Aking Nokma of Nankra Aking by great many supporters of the Mahari members have filed an application dated 18/11/1981 for implementing them as respondent in the said Civil Rule number 936/82 at the High Court.
Yes,
Now,
just a minute.
Yes.
Means by the time
Yes.
when that civil rule was pending, Soramarak was appointed as Nokma
Yes.
in
No.
place of Johnson,
Yes.
isn't it?
Yes.
So because of that, she was included in that civil rule.
Yes.
Yes.
Number 3, ma'am. Ultimately, the opposite parties, for the reason best known only to them, have surprisingly yielded and surrendered in the High Court, though they were apparently fighting their case cause tooth and nail. And accordingly, the said Civil Rule 936/82 was finally disposed of by none other than the Chief Justice UL Bhatt along with the companion judges D. N. Borua by the order dated 5/3/1992.
Yes.
It is.
So your position was confirmed.
Yes.
After the withdrawal,
Yeah, yes, sir.
your position was confirmed.
Yes.
Okay.
Next, please. Learned counsel for the petitioner submit that the petitioner, after that, my lord,
Yes, that okay. Okay, you have read it.
desire to praise this petition and it is dismissed.
So that means your position is confirmed.
Yes.
Come to paragraph 4 next.
Yes, no. In the meantime, the petitioner have instituted the present proceeding for registration of the name of the petitioner number 1 and 2 as the Aking Nokmas of the Nankra Aking in the light of their appointment as Nokma by the Maharis member 127 in number on 14/9/91 and in the light of the dismissal order of the Civil Rule Author by the High Court on 5 March 1992, my lord.
Yes.
Number 5. Following the due process of law, notice was issued to the opposite parties. Both the parties were presented by their lawyer who were heard. The opposite parties have filed their objection by way of maintainability and legality of the petition. And also, chances has given to the parties to submit document. It is a fact that though the petitioner have filed 7 number of documents listed as Annexure 1 to 7, of which the copies were furnished to the opposite parties, have not filed any document to prove their claim. Number 6. In the meantime, the opposite party number 2, Alipshan Marak, has expired, and substitution was allowed on 24/3/1995 in favor of Caxton Marak in the lower court. Since the framing issues are a must even in revenue matter such as the present one, and also especially in the light of ruling of the Honorable High Court held in Civil Rule number 58/78 Durashangma and others, case reported in 1968, GLRR 2/120, the parties have been asked to suggest issue if any, and both the parties have suggested their respective issues. that is 6 by the petitioner and 4 by the opposite parties which were framed by this court. Next, number 8, my lord. The issue number 5, suggested by the petitioner, was taken up for preliminary discussion. In the issue raised was an issue of law. In the other word, the question of res judicata was raised by the petitioner.
Petitioner takes the issue of res judicata
Yes.
against herself or
No, herself.
huh?
Yes. Shura
against
nahi.
herself.
Yes, he raised the receiver
What
in
was the plea regarding the res judicata?
res judicata means
No, that is we understand. On what ground res judicata, plea of res judicata was taken?
because these opposite parties' parents was not a Nokma since 1978 to 2003. my lord. So, as per the
So, according to the petitioner, there is a bar for the opposite party
yes,
to raise the claim.
yes,
So, okay. Now, this simple reading res judicata means we come to section 10 and 11 of CPC.
yes, my lord.
Okay.
But it is reflected in 1988 GLR.
Okay, so that way you can say the maintainability of the plea by just.
Yes, ma'am.
Okay.
Yes.
Okay. Please carry on. Then.
Number 9, because this is core issue which will go to root of the case. This court deemed fit to determine this issue first, which will save unnecessary inconvenience and expenses to the parties and waste time and labor of the court, as it is also incumbent upon the court, as per provision order 14 rule 2 CPC, to dispose the case on such an issue of law even at the preliminary stage if sufficient material are available on record. Number 10. Section 11 of Civil Procedure Code speak of res judicata, and the said section is reproduced here below for consideration. My lord. Shall I read out, my lord?
That is not required, but then
it is not required. My lord.
Why this provision is so long?
Because so many other things also they have included. Number 11, my lord. Eleven also just they are maintaining this one. Anyway, I will read my lord. But before application of the principle of res judicata, court is legally bound to see.
Anyway, come paragraph, read paragraph 12.
12. Okay, my lord. Yes.
Until and unless you want to read paragraph 11.
Yes,
Do you
yes,
want to read?
Yes, yes. It is an admitted fact. The opposite parties have filed an appeal number as Civil Rule 936/82 in Guwahati High Court against only Sri Jongshan Momin and Rane Marak. It is also an admitted fact that the present petitioner Srimati Shura Nankra Marak and Shimran Momin have filed subsequently the miscellaneous petition in Civil Rule Atom Alert for implementing them as necessary parties on the strength of their being appointed as Nokma by the majority of the claimed people on 14 Ato. And this matter was very well known to the opposite parties, as notice rule was issued to them in this respect, and that is the reason why the opposite parties have not challenged the veracity of the fact at the time of hearing in the court, because the copy of Annexure F, copy of letter of 27/12/91 written by the petitioner advocate at the High Court were furnished to the opposite parties along with other annexure in course of the present proceeding. This being the factual position, this court has no other option but to believe that the petitioner were a party to the said proceeding of Civil Rule number 936/82. So were the opposite parties in the High Court, and the said proceeding has come to an end on 5/3/92. Where the Alipshan Marak and Mane Marak did not desire to press the petition, their appeal, in the High Court. Therefore, accordingly, the subject matter of appointment of the Nokmas of Nangkra Aking has become a finality and never to open up again in future in the light of the final order in civil rule number 936/82 dated 5/3/92 by the High Court. To be more precise, Alipshan Marak and Mene Marak, and for that matter, even Caxton Marak, which is substituted as the legal representative of the deceased Alipshan Marak, claiming to be successor in interest, cannot claim the Nokmaship of Nangkra Aking subsequently to the order of the Honorable High Court. If they put up any claim for the Nokmaship of principle of reciprocity will attract. And this doctrine embodies that one should not vex twice for the same cause and there should not be the finality of litigation. Number 13. As per Sarkar CPC is not confined to the issue which court is actually asked to decide, but it confers issues or facts which are clearly part of the subject matter of the litigation. So clearly have been raised that it will be an abuse of process of the court to allow new proceeding to be started in respect of them. Number 14. That being the legal position, this court has no hesitation to arrive at the definite finding and conclusion that all the conditions required for application of principle of res judicata as discussed above have been met within the case in hand. In short, both the parties were hesitating over the matter of appointment of Nokmaship for Nangkra Aking, and that the opposite parties have given up their claim. The High Court has given a final decision, and that the same matter is reopened by the same parties here in the court as well. The appointment of Nokma for the Nangkra King, therefore the court is basing on all the relevant material evidence on record, hold that it is a fit case to apply section 11 CPC for the greater interest of justice, equity and good conscience, and dispose of the proceeding finally at this preliminary stage itself. On this issue alone, decide the issue in favor of the petitioner for the reason stated above. Number 15. I have carefully perused also the affidavit executed by the Jongshan Momin before the Additional District Magistrate Tura West Garo Hills on 25th August 1994, stating that ultimately the Nangkra clan people elected his Sadhuthang, that means brother-in-law. It is written brother-in-law, Sri Simran Momin and his wife Shura Nangkra, petition number 1 and 2, as the Nokpa of Nangkra King. And he accordingly accepted their election as Nokma. He further stated in the affidavit that he has voluntarily relinquished his Nokmaship as publicly declared it and has given in writing the same in the meeting held by the Nangkra clan people on 14/9/91. While the selecting the new Nokma for the Nangkra King, and accordingly this court has no hesitation whatsoever to accept the said affidavit of Sri Jongshan Momin as a legal evidence and conclusive proof of his voluntary relinquishment of Nokmaship of Nangkra Aking dated 14/9/91. That is the reason why he has not made any claim of Nokmaship here in this court as well. In the result, this court arrived at the conclusion that since then a vacancy has occurred in the office of Nokma of Nangkra Aking. Therefore, Annexure C, that is minute of the meeting held on 14th and the resolution adopted and signed thereof by 127 members of the Nangkra clan people, and the election of Srimati Sri Shura Nangkra Marak and Sri Shimrang Tengre Momin as the Aking Nokma of Nankra Aking is perfectly in accordance with the social custom uses generally practiced by the Garos in selecting the Aking Nokma as accepted. I accepted the same. 17, my lord. From the fact, discussion and finding as cited above, I am inclined to accept the case claim of the petitioner and accordingly appoint the petitioner number 1 and 2, Srimati Suranankara Marak and Shimran Tegre Momin as the new Nokma of Nankra Aking with immediate effect and direct the entry of the name in the Nokma registered geological tree and wherever so required. In the result, the petition is finally disposed of. I pass no order as to cause, my lord.
Now, is CPC applicable before the proceeding in district council?
Yes, my lord. As per the ruling of Dore Shangmar's case, my lord, para 23, my lord, it is clearly mentioned, my lord, I have.
It's okay, we have it. Yes, para 23. Come to para 23.
Yes. Para 23, my lord. Shall I read out, my lord?
It's not very legible. You have a better copy. Do you have a... Your copy is legible.
Yes. Yes. I have.
You have a copy, extra copy. Just supply us. There are 23.
Yes, my lord.
Yes.
Because of what has been, may I please your lordship, because what has been stated above, we are of the firm view that the principle of res judicata, which is founded on equity, justice and good conscience, has to apply to proceeding before the revenue member also. The Deputy Commissioner Mr. W. Shaw, having held as early as 4 January 1937, that is more than 5 decades before, that the petitioner Dora Shangma was the Nokma being Khangse's own daughter. It is also too late in the day to disturb that finding. May we state that this dispute in the present case is between the petitioner who are claiming through Khangse.
This is all right. You don't have to. It talks about principle of res judicata.
Yes.
There is no dispute to it.
Yes.
Because it's a otherwise general principle.
Yes, sir.
If a matter stands decided between the parties, it should not be revisited.
Yes, yes, yes.
But then the question is that whether CPC was applicable. That is the
This judgment itself, my lord, it says that the spirit of CPC should be applicable where recording of statement of the depositions of witness, my lord, then both the parties should be heard. This is the 4 guidelines.
Dora Shangma's case.
Yes,
okay,
Dora
we know. That is, see, that basically that emanates from the principle of natural justice.
My lord, yes.
That
Principle of
evidence
natural
has to be,
justice.
issues has to be framed,
Yes.
evidence has to be recorded, and there has to be a decision, pronouncement of decision on each and every issue.
Yes.
There is no dispute to it.
Yes.
But then would it mean that the CPC applies to a proceeding?
No.
Anyway,
My answer
whatever
will
it
be
is,
no.
all right. Okay, then what happened? How? What basis CM interfered with this order? This order is in your favor.
Yes, my lord. Then they have
The
passed.
sum and substance of the order is that once you forego your claim before a High Court, you subsequently cannot come and revive it. Try to get it revived.
Yes.
Isn't it?
Yes, my lord. Then this order has been challenged. It is
Order was challenged before the CEM, my lord, and CEM has reversed this order.
Yes, that is what.
Yes, my lord.
That is the impugned, isn't it? That is
Yes,
the impugned
yes,
order.
yes.
We want to see that one.
What is
the ground? Yes, Mr. Hajarika, where is that order?
Yes, 17.
It's just on the next page of the
137.
synopsis.
Page 137.
No, my lord. No, my lord. Just a minute.
It is in the synopsis, my lord.
It is in the synopsis itself, my lord. The next page.
No, but
after
in
the
the writ
EM
petition
summary.
also it is there, page 137.
Yes, my lord. 137 is there, my lord. Yes, my lord. In the writ petition also is there, my lord.
Yes, that is a typed copy. You can read out from there only, Mr. Hazarika.
Yes, then this order, this one 23.
It's a big order.
It is a big order.
Now, before
this, my
GM
lord.
passed the order, he had framed for issues. Did he frame, or it is only on the basis of the preliminary issue of res judicata?
Everybody.
So it means no
issues.
evidence. No evidence was recorded.
Yes, it seems.
And what is the order of the CM?
Same in the synopsis, my lord. And
82, page 82. my lord.
82, my lord. This is the type copy, my lord.
Just a minute. Where is the synopsis?
Order dated
Just a
23.
minute. We are not finding the synopsis. Let us first find where the synopsis is. Yes. Written synopsis.
Yes.
Find on 8/11/2023.
Yes, my lord. 23/12/2003, my lord. Reverse this order of 7.
No, just a minute. Just a minute. Okay. You filed your written synopsis on 8/11/2023. Where is the page?
This is number 82. my lord.
82, 82.
There is no pagination here. It's not been paginated here.
Annexure 11,
How
page
to find out? There is no pagination here.
Annexure 11, page number 82, madam.
Things are not maintained the way it should be.
Annexure 11.
Give me, let me assist you.
Wait, Mr. The problem is that there is no pagination. Wait.
Yes.
This is-
Yes. Yes.
Yes, yes.
It should be properly paginated. How we will get it? Whoever does. Yes, please.
May I
Page
please-
82.
Yes, my lord. May I please,
Oh,
your
sorry.
lordship.
Page. This is according to you. This is page.
Page 82, my lord. Same, my lord. Shall I read out, my lord?
Yes, yes. Read out means like you just tell us if you have to go through this whole order. I do not know whether it is needed or not. Otherwise, you can take us to the relevant person, the grounds, based on which he interfered with the order.
Then the here number also not here, my lord.
Or if you want, we can go through this also. But then, will it be required?
It is not much longer.
3-page judgments only.
Okay. 3-page judgment. Okay.
This appeal is against the judgment and order dated 17/2/2000 passed by the executive member Revenue in case number 9 of 92/93. The appeal is filed by Srimati Mene Marak, registered Nokma of Nankra Aking, and admitted while the appeal case is going on in the appellate Srimati Mene Marak expired. The right to sue the survived by the Nokma daughter Sri Moti Madeline Marak and other daughter of Nokma, Mene Marak, and Srimati Madeline Marak is substituted being Nokma daughter, who is have considered and allowed. I have perused the appeal memo and rejoinder filed by the appellant and the respondent respectively. I have perused the case record of the lower court and the order dated 17/2/2000. On perusal of the relevant document and the connected paper, I found that at the relevant date of order passed by the executive member, Revenue, the registered Nokma Srimati Mene Marak is still alive and is still registered Nokma of Nankra Aking. I have heard the submission of the counsel of the appellant as well as for the respondent. The counsel for the appellant submit that the predecessor in interest of the appellant are registered Nokma of Nankra Aking. The appellant as well as substituted Srimati Medalin Marak belong to Nankra clan of Nankra Aking. Srimati Medalin is the own daughter of the registered Nokma and also great-great-granddaughter of Nokma family lineage and had directed bold relation right from the first registered Nokma, Dr. Mulia Sangma and his wife late Arim Marak Misik Nankra. In support of his claim, he cited the reported in 1988 GLR 120 that the Aking land belonged to the motherhood and the same in the joint property of the whole motherhood. The Garos or material system as descendant is always traced from the mother alone. Through her is traced its origin back to the great common ancestress. The appellant Srimati Medalin Marak has her origin from the first registered Nokma Mulia Sangma and late Arim Marak. Further, Srimati Medalin Marak is the daughter of Nokma Mene Marak. Therefore, she has every right to Nokmaship of Nankra Aking. He further submit that the Aking land belongs to the female Nokma and the male Nokma cannot do anything against the will of Nokma Misik family and the clan people. Therefore, the earliest withdrawal of the case before the Honorable High Court by male Nokma without the explicit consent of Nokma Misik family and the clan people is illegal ab initio. The counsel for the appellant submit that the predecessor in interest of the respondent never been registered Nokma of Nankra Aking and they have no link with any of the registered Nokma. They do not belong to the Nokma village of Nankra Aking. Therefore, they have no right to claim for Nokmaship of Nankra Aking. The counsel for the respondent submit the written argument. In his argument, he mostly stressed on the law point and procedure of CPC. He also submitted the point of agreement on the decision of the Honorable High Court, in which case before the High Court was withdrawn, and I have perused the written argument filed by the counsel for the respondent. As discussed above, the appellant has a direct blood relation to the Nokma Nongtang village and thus she has every right to the Nokmaship of Nankra Aking. On the other hand, the respondent did not have any link to the Nokma Nongtang village of Nankra Aking. Their claim is only through the withdrawal of the case pending before the High Court. This claim cannot be considered for Nokmaship. Then, against this order, my lord, being aggrieved because they have given that there is no release, whereas they are coming from Jongshan moment to his uncle during that relevant period. Rikmani was very young, so her uncle Shoranankra and the Shimran was selected by the Mahri and given, and subsequently Rikmani has come. So this order is, according to us, is not the correct order. Being aggrieved by this order,
Just a minute. Yes.
Now I am going to the against this order. We prefer and
Come to High Court.
High Court, my lord.
Where is that order?
Order is 86, my lord. Page number 86. And
Yes.
then 87, my lord. I will read this order. That copy also is there, no? Yes.
What happened in High Court?
Yes. High Court has set aside this order, my lord.
What is the operative part of the order?
Order is.
What is the reason?
Reason is that they are making the blood relation. In fact, there is no blood relation with the previous Nokma. Because
show us the come read the finding.
That is not a correct thing, my lord. What the High Court has found out, my lord, that a blood relation on which, my lord, the CEM has set aside the order of the EM, my lord. On what basis he is saying that they doesn't have the blood relation? On the basis of that, my lord, the order of the CEM has been set aside and remanded back to the CEM for fresh trial.
It will be clear by this order.
The High Court said that the finding was not based on
any material.
Materials on record.
Yes.
So that is the reason interpreted.
It has been.
But then High Court did not say that they are not.
No. And High Court has remanded back for a fresh trial before the CEM.
Yes, obviously, because High Court will not be able to say it
Yes.
in the writ jurisdiction. So that is only the procedural irregularity.
Yes.
Then I will go to para 3, my lord, of this.
Just a minute. You will just take us to that operation, the finding of the High Court.
Yes, my lord, I am para 3, my lord, page number 93.
Page 93, the type copy.
Type copy, my lord.
Para 4 is relevant, my lord, for his case.
And you just. Yes, para?
4, my lord.
No, just.
Now
just,
para 3, my lord.
Yes. Let
It
us
is
see.
related, so next para will be confused, my lord.
That is not finding, isn't it?
No, that is not the
There is
finding.
no specific finding. It is only on basically.
No, what we want is to just show us to the part by which.
Now I come to para 4, my lord. That is it.
Yes.
Para 4, page number 94,
Yes.
my lord.
That is better.
A consideration of the order dated 17/2/2000 passed by the learned executive member in charge revenue of district council in favor of the present writ petitioner will go to show that the eventual conclusion recorded in the said order was based on consideration of the earlier order passed in this regard, that is the order dated 23/7/76 passed by the learned executive member in charge revenue, the affiliate order dated 3/3/78, while revising the said order, the learned chief executive members by his impugned order 23/2/2003 has recorded finding that it is the respondent number 1 in the writ petition, that is appellant, before this executive member who was related by blood to the original Nokma, that the withdrawal of the writ petition registered in civil authority by the predecessor of the respondent number 1 appellant will be of no consequence. The learned chief executive member, while rendering the appellate order dated 23/12/2003, has not indicated the basis on which the conclusion that the present respondent number 1 was direct blood relation to the original Nokma has been recorded. The aforesaid appellate order dated 23rd December 2003 also does not reflect consideration of the earlier order passed by the learned executive member and the learned chief executive member on 23rd/7/1976 and 3/3/78 respectively. If the present petitioner claimed to be the legal heir of the junction moment, surely and certainly, that is important, my lord, Certainly, the aforesaid claim made by the petitioner ought to have been considered by the learned chief executive member in the light of the order of 23/7/1976, my lord, and 3378, in which order the claim of junction moments to be recognized at Nokma has been elaborately dealt with. In any case, there being previous order with regard to the claim dealt with by the affiliate order dated 12/3/2003, it was incumbent on the appellate authority to duly and properly consider the legal effect of the said order, the finding recorded therein, as well as the basis for such finding as indicated in the order in question, the aforesaid course of action not having been adopted, important my lord, by the learned appellate authority. That is order in 23/7/76 and 33/76. I am of the view that the apparent and discernible infirmities have crept into the impugned affiliate order dated 12/23/2003, which will call for this court interference.
Yes. Then what happened?
Then number 5, my lord.
No, that is okay. They skip this order. High Court interfered.
Yes.
Matter was sent back. Then?
Yes. Then the matter was referred to the district council, my lord.
Yes.
Then district council passed an order.
CN.
Yes. On 10/1/2013, my lord. Type copy in the type copy in page number 126, my lord. Shall I read out, my lord?
Just 126.
Yes, my lord. Annex 16.
Yes.
The dispute between the parties relate to the successor to the Aking Nokmaship of Nankra Aking belonging to the Nekhra Marak clan. The history of the dispute dates back in 1973 when a petition was filed for recognition and registration of late Mene Nankra Marak and husband Alipshan Marak, the predecessor in interest of Srimati Medalin Nankra Marak, for their registration and recognition and Aking Nokma by the revenue authorities, that is before the executive member in charge, Revenue Garwal District Council, Tura, in case number 35, 1973-74. This petition was allegedly agreed to and supported by the Jongshan Momin, husband of last registered female Aking Nokma, Jamse Nankra Marak. It is said Jongshan Momin was released from Aking customary bond between the two claimants of the husband and wife to supply substitute on the death of either of the spouse to maintain continuity of relationship of the claimant. Jongshan Momin also relinquished his petition as male Aking Nokpa in favor of Mene Nankra Marak and her husband Alipshan Marak. However, at the time of Mojidar inquiry at the beginning of the proceeding, he also reclaimed his Aking Nokmaship after remarrying Lady Rane Marak of Nankra clan. The EM in charge revenue passed the final order 23/7/76 directing the Mene Nankra Marak and her husband Alipshan Marak to be registered as Nokma. His judgment was based on the inquiry dated 1/5/75. Next. Enclosed statement of the parties and clan member and the documents submitted to the Mojidar during the inquiry. Rane Marak and Jongshan Momin filed an appeal.
Not required. So this history, though, we have already got it.
Yes.
Come to the part, I think.
No.
I think there is no dispute with regard to this. Now let us see whether this disposal was in accordance with the High Court's order.
In that case, I will go to the last paragraph, my lord. Number also not there. Page number 133, my lord. Second paragraph. Likewise, before CM, also witnesses were also examined but not cross-examined, and their veracity as witness. Page 133, my lord.
Yes.
Second paragraph, my lord. Likewise, before the CM, also witnesses were also examined but not cross-examined, and their veracity as witnesses were not tested. It may also mention that the claim relationship is very strong in the village level, and differences claim are different ways related to each others.
But that is, we have not understood what he is said to what. Likewise, before CM also, witnesses were also examined but not cross-examined. That is in which context?
That is in the when case is referred to the CM, my lord.
By High Court's order?
By High Court order.
21/3/2006.
Yes, my lord.
Now 21/3/2006 basically directed the CEM.
Yes, my lord.
To go for de novo proceeding after
Yes.
taking into consideration
Yes,
of order passed in 1976 and 78.
Yes, my lord.
Isn't it?
Yes, my lord.
So that is what, after that this order has been passed.
Yes.
Now then, what is this? What is this observation then?
Here it is made by them, that is their wording of the CM. So I will come the next paragraph, it will be...
It is irrelevant, my lord. The relevant portion is this, my lord, in page 135, my lord. They are basically repeating the same thing, my lord. The CEM has repeated the same thing, but the relevant portion is page 135.
Yes.
The parties are directed to suggest issue, in addition to the core issue mentioned above, if any, to submit the list of their witnesses and relevant further documents, if
So
any.
this is not a disposal order. Then.
This is not a disposal order,
Okay,
my lord.
then-
Now, against this order, they have again come before the High Court, my lord. Actually, what happened in the main order, my lord, the CEM, by mistake, has said, my lord, the matter is disposed of. In this order, my lord, there was one more line by which the CEM has said the application is disposed. Instead
Where
of
is that
saying,
order?
now, my lord, may kindly come to the High Court's order. The next page is the High Court order. That is in writ petition.
Just a minute. Just a minute.
I will go for this, my lord.
So far, what you said that CM has made a mistake by saying the disposal of
No.
is where it is.
No, I am...
That is not enclosed. That is not enclosed. Now, against that order, my lord, Rick Bonney has come before this honorable court, and order dated 23/9/2014 was there. Just next page, my lord. If my lord come to the next page, it will be very clear.
Yes.
If I am permitted to read para 3, my lord.
Yes.
Mr. S. The learned counsel for the respondent number 1 to 4 submit at the bar that the executive member, it should have been the CEM, my lord. Garo's Autonomous District Council has committed a bona fide mistake in passing the order dated 10/1/2013. That is the initial order, my lord. Inasmuch as the said Ninkra Aking so-and-so has not yet been disposed of, and the executive member Tura intended to mean in this order is that the issues are framed which are in separate sheet, my lord. Mr. De learned counsel for the respondent 1 to 4 contended that he is having the record of the proceeding of Ninkra Aking so-and-so. For further contended that the concerned EM JGDC Tura had also tendered an unconditional apology of a bona fide mistake he has committed in passing the order dated so-and-so. And the said bona fide mistake is in passing the order dated so-and-so has been corrected to the extent. Now, this has been corrected, my lord.
That in para 4 is the operative part, my lord.
Now, this has been corrected and the matter was fixed for laying down the evidence, my lord.
Para 4 is the main contention, my lord, what they have done.
Now, in this order, my lord.
Okay, so that is what.
Yes.
So in view of the mistake, pointing of the mistake, I could interfere with that part of the
That
order.
part.
Only
And
the way
remanded
it was
back,
shown
my lord.
is that the separate sheet.
Yes.
And then it was remanded.
Remanded back.
Then it's okay. So this order is not of much relevance, is it?
No, no, my lord.
Then
Then,
Then, my lord, the main
my matter
impugn
was
order.
Just a minute, just a minute. Yes. Thereafter?
Thereafter, my lord, the order dated 15/12/2016, which is under challenge, my lord. This is
Where
impugn
is that
order.
order?
That is under writ
Order
petition, my lord,
11.
137, type copy.
that is 137.
That means there's still a requirement for the CM to pass order in accordance with order dated 21/3/2006.
Yes, my lord.
Isn't it?
Yes, my lord.
By taking into consideration that 1976 and 1978
Yes, my lord.
order, isn't it? Now,
Yes.
where is that order? Where is that last order?
Page 137, my lord.
137
Oh,
Of the writ petition.
For the writ.
what kind of synopsis is this? Just tell us.
For that
For
reason,
certain,
I already.
you see, it is difficult for us to take note.
On the first instant, I said, my lord, it's very difficult for us to track up, my lord. So many documents
That is
have
the
been
last,
submitted.
my lord, because for that reason we have prayed before this honorable court to file this synopsis because all the document could not be
But
approved.
then you have not incorporated it properly. Even the first order of EC is not a part of this synopsis. The impugned order is also not a part of this synopsis. Now this court is taking note from this thing.
Only this impugn order is not enclosed in the synopsis. All the other.
Where is that order dated? Order of the EM then?
No, order of the EM will not come into existence, my lord.
No. Where is that order? Has it been enclosed here? 72 to 17 to 2000
Yes, my lord.
in that synopsis.
Yes, madam. It is
Where is
there. That is we have written.
Is there?
This number. Type copy is in page number 60, my lord. 17 to 2000.
16.
Yes, my lord. 60.
So why you have given us an extra copy then?
No,
While
it is-
hearing,
it
you
is-
have supplied us.
No, my lord. That's.
This is
17 to 2000.
page 16. 16.
60, my lord.
60, my lord. The relevant part is in 16. 1, my lord. 17 to 2000, my lord, the order date.
See, until and unless we take up matters in an organized way, it becomes very difficult. You will finish by concluding your submission, then court will have all the problem in locating things or other thing.
This order is already read out.
Now, all these orders which have been pointed out just now,
Yes.
this is not a part of the writ petition. These are part of the writ petition.
Yes.
No, my lord. This is not a part of the writ petition. It was brought by the way of synopsis. Only the impugn order is part of the writ petition.
By
All
the
other orders are not a part
Not
of
part of the writ petition, my lord.
only by
And
the order of the honorable court we have brought all these documents.
Well, it was prayed. It was prayed that can I file a synopsis, and then these orders was brought, my lord.
No, my lord. This
Anyway,
is-
it's all right.
is
There
a
is no
specific
problem.
order
There is no
is there.
problem. It doesn't matter which way it came, it has come.
But the difficulty was this, my lord. There's no doubt, my lord. There's any way he can bring these orders, my lord. But the affidavit that we have filed, my lord. What was before us, my lord, when we filed our affidavit? It was only the writ petition, my lord.
You should have taken an objection on these things.
No, we have
You
objection,
see,
my lord.
so far as the judicial orders are concerned,
Judicial order is there, my lord.
because your affidavit will not improve
No,
or
only thing is this, my lord.
deteriorate the situation.
Only thing is this, my lord. When certain allegation has been made, my lord, we need to counter those allegations. Like for example, my lord, he has said that this order was filed by the CEM and all. What was there, my lord, in record, that was not brought by our affidavit, my lord. We have just concentrated only on the impugn order. The history was not brought, my lord.
Anyway, let us see what he makes out. Let us
My
see,
lord.
since it is if it is required that there certain parts is needed to be refuted, then you will be given an opportunity to file an additional affidavit.
My lord.
Yes.
Yes.
137.
Yes, my lord.
15/12/2016.
Yes.
Yes.
May I please, Your Lordship? I will start from para 4, my lord. Page number 138.
Yes.
Upon perusal of the case record available along with the record of this appeal, I found that number one, the original case GD number 35 of 1973-74 was filed before these executive members and Land and Revenue by Sri Jongshan Momin and his wife Rane and Marak for Akhing Nokmaship of Nankra Akhing. This petition was objected to and counter-claimed by Alipson Marak and his wife Mene Marak. This final judgment and order passed by the executive members on 23/7/1976 ordering for...
This is reiteration of those historical backgrounds.
Yes, my lord.
We know it. So
Yes.
what is the, come to the part,
All are this thing, my lord. Only I will come.
what is the reason for interfering with the EC's order?
Yes.
EC's order dated 17 to 2000.
Yes. I will go to a particular paragraph only, my lord, para only, my lord.
Yes.
So I will go to para 8, my lord. Page number 145.
That is again the same thing.
The same thing, my lord.
Then
para 9, my lord. The GD case number was taken up by the executive member by taking...
this is also same. Para 10 also is same.
Then here, my lord, then the last paragraph.
Okay. From para 10 it may be a bit relevant where both the parties have filed their suggested issues. Para 10.
That is just they are elaborating matter. There is no finding. Only the what
Just
order
a minute,
has
just
been
a
passed
minute, just a
previously, that also only enclosed here, my lord. Repeating the same order in this input judgment and order, my lord.
Yes. What is para 12?
Para
12.
Para 12.
We do not know where from finding started.
Finding is only this 34, my lord.
Your case, you do not know where from finding started.
My lord, may kindly come to page 152, my lord, from where the crack of the issues was answered, my lord. Para 19, my lord. Para 19, he has given the sum up, my lord, and para 20, he start giving the findings.
Para 19 and 21, my lord.
Yes.
No, para 19, my lord.
The
19.
disposal of the matter by EM was on the issue of law, res judicata.
Yes.
Now the finding by the appellate court is on the basis of the facts.
On the basis only they are mentioned in
Now,
the
whether
past.
any evidence was recorded.
Yes,
Is
here.
it not that the EM assumed?
Yes, they have not
some
recorded any
jurisdiction
reason, my
which
lord. No reason. Only in the last paragraph, my lord, 34. They have given the reason blood relation. Nothing else. There is no finding at all, my lord.
No. What is the finding of the CEM with regard to the order of 1976 and 78?
Just elaborating, they have wrongly passed the order. So I will come to this page 19 and 21, my lord.
Page 19 or paragraph 19 and 20?
Paragraph 19, page number 152.
Yes. Yes.
The matter is now before me and the remanded Nankra Aking case number 5 Ato was re-registered as GDC number 44 of 2014 after the High Court order. It is seen that Medellin and Marak file and petition before this court to continue the appeal 13/12/2014 as early as possible, as the matter is not taking a step to start proceeding after remand. On 25/2 of 2015, my predecessor rearranged the parties in the appeal, arranged Srimati Rikmani Marak and her husband Bening Momin as appellant, and Srimati Medellin Marak and Sri Harbat Sangma as respondent. Here is, my lord, only one point I have to point out, my lord. Medellin is okay, but this Harbat Sangma, how he is come into the picture? He is not related anyway to Nankra
You should
claim.
have objected to his inclusion before that CEM.
Just I am pointing out, my
That is okay. Yes.
as respondent. Initially, the appeal proceeded to take a step, and Srimati Medellin Marak filed issue and list of witnesses. Following earlier main order dated 1/10/2013 for suggestion of issue of GDC number 5, Ato, the counsel for the appellant stated that appeal be heard as per direction of the High Court, and the matter was finally heard on 1/11/2016 and posted for order. Then I will come to page number 21, para 21, page number 155, my lord. Then 34 I will go finish. Let me follow.
150?
155.
155.
Yes.
In the appeal before CM against the judgment and order dated 23/7/1976 by the Sri Jongshan Momin and Srimati Rane Marak, which was registered as 12 Miss case number 1977-78. Judgment and order dated 3/3/1978 was passed in favor of the appellant Sri Jongshan Momin and his wife Srimati Rane and Marak. As per judgment, the point on which the final judgment went in favor of the appellant are as follows in the year 1973. Ringbe Marak left the Jongshan Momin and went away with one Margaret Marak. Then the claimed people Ringbe Marak could not supply substitute to Jongshan Momin as per customary law.
Now,
but
how, on what basis he got these facts?
no, as per this High Court order and
these subsequent facts.
Yes.
That Ringme Marak left Jongshan Momin and went away with one Margaret Marak. The clan people of Ringme Marak could not supply substitute to Jongshan Momin as per customary law. But he stayed in the house of. Now these observations, these findings comes from where?
Comes from the order of the Arul District Council. It is in the affidavit in opposition, my lord, they have mentioned.
Proceeding opposition before this court?
Filed by the respondent number.
Yes. Where?
No.
Where is in the affidavit?
Just a minute. Just address the court.
Yes.
Kindly. Yes, this finding which the CM has recorded.
Yes.
Now, what is the basis, on what basis he has recorded this finding?
As per the record submitted by the parties, my lord.
When you, just proceed, let us.
Yes.
Customary law but stayed in the house of parents. It is also appointed that, it is also mentioned that the respondents.
That is the observation of the CM.
Okay, that is based on the earlier record.
Yes, ma'am.
So these are not development after this case was remanded. Okay. Okay.
As per customary law, but stay in the house and he did not go to his parent house. It is also mentioned that the respondent, Mene Marak and Alipshan Marak, applied to EM revenue for recognizing them as a Aking Nokma on the ground that Appellant Junction Momin has relinquished the Aking in favor in their favor, and that Rane Marak is the wife of the respondent, is the sister of late Jamse Marak. This is most important. These findings of the judgment are not factually correct. Which order has been passed by the district council itself. Now, with this impugned judgment, they are telling it is not correct.
Now, this finding was given by the CM.
CM.
The earlier finding was by CM.
Yes.
And later the other CM says this is not correct.
Yes.
Now, if he says it is not correct, he must have said it on certain basis, isn't it?
Yes, ma'am.
So, what is the basis?
Let me see here. These findings on the judgment are not factually correct. Rane Marak is not the wife of the respondent.
He got
Wife
it
of
from
the
where?
respondent, Sri Alipshan Marak and Srimati Mene Marak, is not the own sister of Jamse Marak. They are finding that they are not the sister, own sister.
Now, this finding he got from where?
That is as per the argument of this lower court, my lord. Their
argument can be.
That is, I have no idea, my lord, how he's got the CM got.
See, after the just tell us.
Yes.
After the matter was remanded back.
Yes, ma'am.
And after the matter was taken up, finally.
Yes, ma'am.
All those for leave out what happened in the
Yes, ma'am.
Was there any pleading filed by the parties?
No, my lord.
Mr. There, can you
that is what, my lord, I said record will be required
because if there is factual finding, then if we find that he has recorded this finding and interfered with the order of the CM without any materials on record, then you have a case. Yes. We may not go into all those things. We can say that simply this
finding, simply they are writing.
The finding which he has given,
yes, my lord,
that this finding of the judgment are not factually correct.
Correct.
Rane Maraka is not the wife of the respondent,
yes, yes.
Marak, and so. If it is based on any materials on record,
no, my lord. Just
if it is not,
yes,
then this order will go.
Yes.
Yes, Mr. Piti Sangwa. How CM has recorded this finding?
Yes, Lordship. Here,
on what basis?
Here,
tell us the basis. Do not go here there. Tell us on what basis this finding was recorded. Was it on the basis of any factual assertion by you?
Yes, Lordship. Because
how you made that? How you made the factual assertion?
We have make a statement in our affidavit of opposition because
where before whom? Wait. Your affidavit of opposition was filed before whom?
Before no. Even there is a pleading even in
we are
the
asking about. You have the habit of going slipping away from the main road. You do not know why. The court is asking you some pertinent question. If you say this fact has been recorded on the basis of your assertion, then we would like to say on which way you have asserted it before CEM, not before this court. Do not talk of the affidavit which you have filed before this court.
Before the CEM, we have filed a list of witnesses.
Yes.
And then after they have examined, our statement has been recorded.
So
the
CEM took, wait. CEM took evidence.
Yes.
Where is that? How do we know it from here? Is there any instance? CEM has this order did not say anything that he has recorded statement.
Yes, in the para Lordship is 10 also is reflected. Even in this order also is reflected. My Lord.
Show us where it says.
In order.
whether the issue has been framed, those things with their lordship, 146. 146.
146.
Page 146. The basic 146, para 10. Yes, but then where is the fact that he has recorded evidence? That is.
No, this is of
This is a previous thing, Mr.
1988, my lord. This is not a.
It's the problem. You see, instead of SC,
My
you
lord,
are rather
that has to be
misleading
examined.
the court to something else.
My lord, that has to be examined from the
See,
record.
Mr. Dale, submission has been made without any basis on the
No,
record.
that, my lord, I have nothing to say what my friend has submitted. But the thing is this, my lord, that has to be ascertained from the record only. And in the first instant only, I said, my lord,
What is your
record will be
contention,
important.
Mr.
Now, if we go into the
Wait, just a minute. Whether, because see, you have heard the matter. Now, if you have to give you time to call for the records,
my lord,
you have to give. It will again come after some days, and
Yes.
then by that time, court will lose everything from its mind. That is the problem.
only thing, my lord.
Just let us see. Have you asserted in your writ petition that the finding recorded by the CEM is without any materials or
Yes, ma'am.
materials of record?
Yes.
And what is the reply of district council with regard to that? Please come
They are
to.
telling that they have passed the
Okay,
order.
first come to your averment when is the writ petition. Let us try if we can avoid calling of the record. You have to. Is there any specific statement that there was no materials on record, no evidence was recorded, and he has made this factual observation without this?
That in my writ petition, my lord, page 13, para 11, my lord. Giving the ground.
Yes.
Shall I read, my lord?
Yes.
That the petitioner being highly
That particular, forget about this. Where you have said
that the impugn order
forget about this also is not used.
yes,
These are all factual assertions. Where you say that no evidence was taken and all.
There is no specific statement.
This you do not.
no, there is
This
page
court
number.
ask you very direct question and you try to this.
No, no,
There,
no.
Nothing will gain before this court until and unless.
May I please, your lordship, para page number 14, para 4, my lord.
What did you say?
Yes.
Read.
That the impugn order is found that there is no funding at all by the, but only mention the chronological event, that also wrongly putting the date and order, etc. in the last paragraph.
The court
It
is asking you one thing, you are reading another thing.
No.
Where is the statement that no evidence was recorded? No pleading was made by the parties, no evidence was recorded, and the CEM has given his finding on the factual aspect without basing on the materials on record. You have not said it, then you have to call for the records. There is no other.
Now, before, my lord, if I can just add, my lord, here. In the best, my lord, if the submission of my learned friend is supposed to be found to be truth, my lord, the best thing, my lord, is a court can remand back, my lord. But even if after remanding back, my lord, the operation may be successful, my lord, the patient will be dead. Here, why I am saying so, my lord, the custom has not been pleaded. There is a judgment of this honorable court, my lord, where custom has to be pleaded, my lord, because there is no codified law at present. Now, my lord, may kindly see Annexure 1, my lord.
See, this plea you raised before CEM. We will not go into the merits of the claim and counter claim.
No, my lord. What I am pointing out is this, my lord. My learned senior, no doubt there is a locus because he was before the EM, before the CEM and all. Now, my lord, from where the strength he is deriving to become the Nokma has to be examined by this court, this honorable court.
See, this is good enough. He has showed some prima facie case when this writ petition in 1992 was withdrawn.
My lord.
So definitely,
Now,
legally, may not be total principle of res judicata, but then the estoppel will come.
No, estoppel will come.
Okay, so once you forgo some right, you cannot.
No, my lord. Okay. That has been answered by the CEM. That has been answered by the CEM. When the why
we do not know, Mr. Dev. You are standing to defend whom we do not know.
No, my lord. I am defending my order, my lord.
Very pertinent question the court is asking. Yes, that the factual aspect recorded, the finding recorded by the CEM, whether it is based on any materials on record. If you can show that it is based on materials on record,
my lord, that has to be pleaded and we are supposed to rebut it, my lord.
Court can take. Court is exercising judicial review. This is 226 extraordinary
I
jurisdiction.
have no dispute about that, my lord. What I have submitted when my learned senior has started the matter, my lord, that record will be required. Second point
You
is
said
this.
it. You were correct. We did not understand.
No, I'm not saying that. my
Now
lord.
we say that yes, you are correct.
My lord, what I'm saying is this. Now, if you would have made a statement, definitely we have to give a categorical statement.
You said so. You
Ah.
said so. We appreciate that part. You said that he has bought on certain materials on record
Exactly, my lord.
for which he did not get an opportunity to answer.
Yes.
So we will not go into
Now,
controversy.
even if my lord record is found to be truth, my lord, that whatever statement he is making, my lord, but he has not made any statement, my lord. He has not made any statement that evidence was not laid down, my lord.
It is
How?
there, my lord.
It was not
In the para 10, my
That is
lord.
Mr. Hazarke, you have not even argued. This is a question put by the court.
When I'm submitting, my lord, by managed seniors should at least allow the juniors to argue the matter. My lord. My lord, here what I'm saying is this. My lord, may kindly come to an actual part. I'd just like to point out one fact.
Say, before.
From where he is deriving the Nokma ship, my lord. The Nokma is basically the mother and the daughter, the best daughter.
Let it be approved by the private respondent. Anyway.
No, but
You are only the deciding authority.
no, but my
You
lord,
are not. You have nothing to do with the origination of right of any of the parties.
No, what
you say that what is correct and what is.
my lord, what I'm pointing out is this, my lord. What was placed before us, my lord, on the basis of that we have given the order.
This court will definitely not go into those questions in exercise of its power of judicial review. We will just like to see the records.
My lord, I will place the record.
Yes, hard learned counsel for the parties. You can follow. Do not record that Moses in it. It appears that production of record proceeding in GDC dash GDC capital dash revenue REV stroke appeal number 41. You will get it at page 136. Is necessary. For determination as to whether the finding recorded in the order dated, in the impugned order dated. What is the date of this order, Mr.
15/12/2016.
Where findings, where based on any materials on record or not. Stop. Paragraph. Mr. Day, learned counsel appearing for the respondent GHDC shall produce the related record by when?
After 2 weeks, my lord.
Before the next, on the next date of hearing. Do not say before, on the next date of hearing. Stop. Yes, wait for, comma, list after 2 weeks. Now again the same thing will happen. The problem is that the application of mind, you see. Which matter is getting delayed and delayed and delayed and then.
Yes, it is there.
This matter was heard and it was kept CAV. But since the annexures was not enclosed, my lord.
By this court?
No, not by this court. By the court number 3, my lord.
Yes, there are many, I've seen the many notings. Not of one day, there are many days.
However, it is a judicial
But
order.
then it happens, you see, like when fact is
Yes.
very lengthy.
Exactly.
Now to understand it and to appreciate it properly, definitely takes time. Okay, the next. It will come after 2 weeks. We have
My
said.
lord, my lord.
Isn't it? Yes.
My lord.
Item number 8.
Master bless.
Yes.
Well, this is that matter, my lord, where we have challenged the order of CM, my lord, whereby, my lord, if, the CM had set aside the order passed by EM executive member. And in doing so, my lord, he had exercised his power under revision. Whereas, my lord, under the rules, there is no revisionary powers as such. My lord, on the last occasion, my learned senior friend here, who was appearing for the private respondent, my lord, he had conceded that if the court allows, my lord, the order which is impugned in this proceeding, my lord, can be set aside and the matters can be disposed of that way. But,
It can be remanded back. If it is set aside, that it has to be remanded.
remanded back. Or if that proposition, my lord, is a
No,
fair
but then, if will it be remanded back as a revision?
No, my lord.
Then
That order, my lord, they will have to take appropriate recourse after that.
that's available to them.
Yes.
So we can record that you are conceding.
Your Lordship.
There is no problem in it. Okay. What is the order which is under challenge?
17.
Not the order.
What is your prayer?
My lord, my prayer is to set aside the order
14
dated
to
14 to
2017.
2017.
Annexure 6, page 1,
Awesome.
page 44.
This hard London Council appearing with the process. Paragraph, but is it petition? The petitioner has challenged in judgment and order dated 14 to 2017, passed in revision petition number 2 of 2016 by the respondent number 3. Stop. The prime contention raised by the petitioner is that the respondent number 3 has no authority vested in him to exercise revisional power, and the passing of the impugned judgment is nothing but an abuse of process of law. Stop. The learned counsels appearing for the respondent do not dispute the contention that the respondent number 3 had no authority to pass the impugned judgment and order. Stop. Paragraph. In view of the above, the order dated 14 to 2017 the respondent number 3, if I, that is chief executive member, Archival Data Council, Pura, is hereby set aside and quashed. The writ petition stands allowed.
Only one observation that the
Needless
private
to say-
respondents.
Okay, just before this thing, before that thing, you say writ petition is allowed. Just before that thing, we just say, needless to say, that the respondent number 2 shall have the liberty to seek remedy in accordance with law.
Yes, sir. Respondent
Seek
number
remedy
7.
available to
7.
him in accordance with law. Stop.
Respondent 7.
Respondent number 7. Okay.
In
Then you
accordance-
say, then in last time you said that writ petition is allowed in the aforesaid terms.
Obliged.
Duly allowed.
Item number 10.
Yes, Dr. Muji, it will be lengthy matter. This is a lunch break. We can have it after.
I will see 1 week time.
Any objection to that?
No.
1 week is all right. For us, we do not know. 1 week.
Two weeks.
Yes, one prayer made by Mr. Joshi, learned counsel appearing for the petitioners. Not objected to by Dr. Mojika, learned DSJ. This is matter after 2 weeks. Yes, deeply.
11.
Yes. Okay, just call 11. Yes.
This matter will take some time, Lordship.
So what shall we do?
It can be taken up.
2 weeks.
No, it can be taken up at the second half also if you see
It's up to
necessary.
you. If you are agree, then court will come back. There is no problem in it.
Next week. After a week, Lordship.
After a week, we have difficulties. See, roster,
Then
see.
any other
We'll
date,
go after
as
2
per-
weeks if you want.
Lordship.
Same order like before. The same previous order. Yes.
Okay. 11 and 12, Lordship.
Both the matters.
15.
How many more matters are there? Okay. Yes. Now you have to shift. Yes. Yes, Mr. Abraham.
Yes, on last occasion, I have requested this senior counsel that to take up the matter today, but he said he'll have a talk with the senior counsel K. Agarwal Kamal. So I don't know what was the talk between.
No, but then what is your prayer? You were there appearing as a party.
Yeah, because I said that I have requested this counsel for the petitioner.
After 2 weeks.
So on prayer made by Dr. Majika.
Let it be after 3 weeks then if that be. So 3 weeks.
On prayer made by Dr. Majika, learned counsel applying for the petitioner. This is matter after 3 weeks. Yes.
Hello, Blake Cholache.
Hello.
16.
Yes. Mr. Thapa.
This matter pertains to, my lord, quashing. We are seeking quashing of a criminal proceeding before the trial court.
Not a POXO case.
Not a POXO case, my lord. It's a case under 326. My lord, the parties have reached settlement.
Okay.
And therefore, my lord, we have filed this quashing
Not
application.
compatible. 326 JBS order.
Non-compoundable, my lord. Only
Who is
of
the
that.
private respondent here?
Private respondent, my lord, was represented by Ms. N. Gurum.
H3. Question number 4 and 5. Yes. Not present.
Today she was there, but it appears she has left already, my lord. So some difficulty. We can have it after 2 weeks, my lord.
No objection.
At the request made on the at the request of Mr. Thapa, learned counsel applying for the petitioner. List after 2 weeks. Yes.
Deeply.
18.